If we look at the perspective from avoidable litigation, where franchisees, franchise attorneys, where they sue franchisors, we're going to discuss 3 reasons why. Reason 1 is compliance violations. Reason 2, I'll call it unit economics. And reason 3, operations and support. And we're going to do it with a mindset and perspective of giving you the information and know-how to help hopefully avoid litigation or mitigate your litigation risk. Lawsuits and litigation, it's never fun for any business owner. And this is especially the case for franchisors. The good news, lawsuits, litigation, many times it's avoidable. And the bad news is it happens. And so we're going to discuss 3 reasons why franchisors get sued and what you could do to avoid and mitigate your litigation risk. As a franchisor, sometimes litigation is unavoidable. It's needed. You need to protect your franchise system, and day in and day out, when we're speaking with our clients, when we're having conversations, whether it deals with franchisee non-compliance or it deals with protecting your brand, we're always evaluating a cost-benefit analysis. Stability of your franchise system versus suing a franchisee or being sued by a franchisee. If we look at the perspective from avoidable litigation, where franchisees, franchise attorneys, where they sue franchisors, we're going to discuss 3 reasons why. And we're going to do it with a mindset and perspective of giving you the information and know-how to help hopefully avoid litigation or mitigate your litigation risk. And before we go into 3 reasons, also keep in mind who's out there. You have your franchisees, you have franchise attorneys. Some of them are working on a contingency basis. Some of them are working on an hourly basis. Some of them are looking for insights or access to your franchise system through 1 or 2 franchisees that may be recruiting others. No matter how lawsuits or litigation come about, know who the players are. And the 3 reasons why, or the 3 factors they're looking for to open up a lawsuit or start challenging your franchise system. Reason 1 is compliance violations. Reason 2, I'll call it unit economics. And reason 3, operations and support. And we're going to go through each of these, but I'll set a foundation. As franchise counsel to a number of amazing brands, many of our day-to-day conversations have to do with mitigating litigation and litigation risk. And this addresses a number of issues of how we deal with franchisees, what happens with franchisee defaults, how much latitude do we give a franchisee if there's multiple instances of a default, and also operationally, what is your operational team doing on enforcing training standards, creating a cadence of compliance, whether it's monthly or weekly financial statements or franchisees achieving certain goals, right? So the idea is we want to create a compliant franchise system. Our primary goal is to avoid litigation, grow your franchise system, have profitable franchisees. But unfortunately, like any business or any industry on this planet, litigation happens. And who are the players that we're going to speak about? Well, you're a franchisor, you have your franchisees, and then naturally, many times the catalyst for franchise litigation, the lawyer, right? And when we're dealing with franchise lawyers, there's a couple of different approaches they take. A franchisee lawyer. You have franchisee lawyers that operate on an hourly basis. So the franchisee, if there is a dispute, they're paying that lawyer on an hourly basis. They're investing their capital. But there's also lawyers out there that operate on a contingency basis or a hybrid model, a lower fixed fee and a contingency based on a percentage of what they achieve in any recovery from you as a franchisor. In those instances where they're working with contingency lawyers, you want to be even more careful because that lawyer is incentivized to sue you, whether or not there's legitimacy or a strong case, I should say. So as we're considering litigation, understand not only are you dealing with your franchisee that may believe they're harmed or damaged, but they may be recruiting or recruited by an attorney that is looking at this dispute as a profit center for their business. And it's kind of repulsive, but it's out there. And this is what we need to deal with. 3 reasons why. So the goal for this video, we want to cut down on litigation. Good news is it can be. And many times in the franchise world, litigation's avoided. Franchisors want the best interest for their franchisees, and franchisees act rationally. And when there are disputes, sometimes we go to mediation. We have a great mediator, and it's resolved. So the good news is that from an industry perspective, for good franchisors, litigation can be managed and is completely controllable. Let's go into the 3 reasons why. But when the dispute arises, a franchisee attorney, one of the first things they look for, low-hanging fruit. Can I look at the FDD? Can I look at the franchisor's registrations? Can I look at their practices? And can I identify a technical violation? FDD disclosure, registrations. Almost every time a franchisee attorney sends a notice, they're going to claim some deficiency or misrepresentation in the FDD itself. And usually these compliance violations, they're not the cause of the dispute, but franchisees and franchisee attorneys, they're looking for those compliance violations as a leverage point. Right? They're looking to say, hey, even if you're right, or even if my client underperformed as a result of their lack of effort, you violated the franchise law. And so how do we avoid this? Compliance, right? On an annual basis, even on an interim basis, really deep diving into your FDD, its updates, the information that's being reported. Your compliance process, right? For our clients, we have our FranIQ compliance system. So as a franchisee is sending out a disclosure, sending out an FDD, our FranIQ system is monitoring everything, right? Where do people go wrong with disclosures? One, they don't get a signed FDD receipt, right? If you're sending the FDD electronically, your receipt page needs to be a part of that complete disclosure, and a franchisee should be signing electronically and then vaulting that electronic signature so we know we disclose properly. Another compliance violation we want to be aware of, that you're registered in the registration states when you disclose your FDD. And sometimes franchisors they make mistakes in error. Maybe a franchisee is going to open up a location in Florida where registration isn't required, filing is, but we find out that the franchisee is a resident of the state of Maryland, in which case then registration in Maryland was required. So compliance violations, they're low-hanging fruit. They're reasons, they're not generally the reason why the lawsuit started, but franchisee attorneys, it's their first point of attack. They're going to be scrutinizing your compliance, and the way you avoid it is have a thorough compliance system. Your FDD updates, your FDD disclosure, how we document and send your franchise agreements, how addendums are prepared, and how we document the process itself. So reason one, compliance violations, they are avoidable, will almost always be an argument by a franchisee attorney. Don't give them low-hanging fruit, and don't give them a free shot at your franchise system. Reason number two, I'm going to call this unit economics, and this is a bucket reasons why franchisees sue. And this second reason, unit economics, more often than not, is the catalyst for franchisee litigation. It's what motivates them to speak to a franchisee attorney, and it motivates franchisee attorneys to maybe go out and try to recruit other franchisees in your system. So what do I mean by unit economics? Well, let's set this up at a macro level. One of the greatest catalysts is a franchisee bought into a franchise system and feels like they didn't achieve or weren't given the opportunity to achieve the unit economics they expected, right? At a base level, everyone is buying a franchise as a business venture to make money. And in these videos, we talk often about, as a franchisor, it's critical in your FDD, your franchise sales process, to understand the economic profile of your opportunity, right? Are we a lower startup cost, maybe home-based business or mobile business, where the franchisee financial expectations are lifestyle or supplemental income? Or are we a higher investment franchise, higher initial franchise fees, initial investment, where a franchisee is expecting income replacement or legacy building? So the biggest catalyst for disputes is where a franchisee is sold a franchise, they buy into a franchise system, they invest their money, and they feel like, not that there is, but they feel like there was a bait and switch, that they bought a business for income replacement or legacy building, and it hasn't turned out that way, right? So it's important to always ensure, when we're talking about unit economics and how to avoid litigation, it's always important to make sure that you're not overselling your franchise. The economic opportunity you offer is clear and consistent with the capability of your franchise opportunity, right? The value of many home service-based businesses is that they're generally lower startup costs with income replacement potential, and that puts them in a sweet spot. Where I see franchisors run into trouble is maybe they are a lower startup cost business and there's only so much you can do with it. Maybe it's mobile. And for the typical franchise buyer, they're only going to operate in one territory. And maybe the business is just a supplemental income business with a nominal, or not nominal, just a basic level initial franchise fee. The problem we see where expectations don't align is maybe if that franchisor is working with a franchise sales organization, with franchise brokers who are incentivizing, or the franchisor feels like they should sell multi-unit opportunities or multi-territory opportunities. So now instead of having a franchisee that buys one territory at say 35,000, they buy 5 territories, have spent 150,000 on initial fees. Why does that create imbalance? Because that franchise buyer is now expecting something substantial. They're investing 150,000 versus 35,000, and they're probably expecting income replacement and legacy building. If your franchise system can't support that, then you're creating a foundation or planting a seed for future litigation. That franchisee is going to be unhappy. You'll have paid a ton of money of initial fees and other items to brokers or franchise sales organizations. And now you're left with a franchisee who, if they bought the business as a supplemental income business at with a lower investment, may have been a raving fan, but now as they realize they can't scale through territories, they've spent a ton of capital, they're not replacing income, you have a disgruntled franchisee that's going to be incentivized to start litigation. So unit economics, one of the biggest, reason number 2, one of the biggest reasons under the unit economics banner is misaligned expectations about what your franchise opportunity can help them achieve from an economic perspective. Is it lifestyle? Is it supplemental income? Is it income replacement? Is it legacy building? And to that point, so many times, whether it's restaurants or service-based businesses, maybe your business can help them achieve those goals, but there becomes misalignment because maybe you've sold them too many territories or you sold them too many multi-unit opportunities, right? Maybe the better pathway, have the franchisee spend less money upfront as they buy a franchise, get up and running, be successful, then focus on their second unit rather than depleting capital that many times doesn't even go into your franchise system. So on unit economic front, it's an imbalance between the opportunity of your franchise offering. Still under this unit economic banner, financial performance representations, right? So in your FDD, a couple of ways this will be triggered. One, if you're not making item 19 financial performance representations, it's almost counterintuitive, but you become more prone to litigation. Because if you have a good disclosure in your FDD of here's the financial information we provide, and this is all we provide, you're less prone to a franchisee or franchisee attorney potentially fabricating a claim that you made unauthorized financial performance representations outside the scope of your FDD. So when we're looking at item 19 and financial performance reps, not only are we looking at it from a perspective of educating and informing buyers, of course, this is information you provide, you as a franchisor, you're the only person making these financial performance representations, right? So in that item 19, the goal for you is to provide a clear picture of the economic opportunity and to do it in a way that's representative of the franchise, but also do it in a way where it makes it harder for people to maybe misstate or fabricate claims that you made unauthorized representations. So an item 19 can actually be a legal defense. Other ways you could get sued with financial performance reps, well, if you have a sales team, an outsourced sales team, or someone else that is making statements that go outside the scope of your FDD, of your item 19, right? The rule in franchising, you can't make any financial performance representations. Only financial information you could give is what you properly disclose in FDD item 19. So if you have a salesperson or outsourced sales organization that's making claims that rise to the level of financial performance rep, operating margins, profit, unit costs, how long it takes to become successful or profitable, it opens up the door to litigation. And to that end, also, you need to be very concerned and severely scrutinize pro forma. What's a pro forma? Many times franchise sales teams want to say to a franchisee, hey, here's a spreadsheet that identifies potential income categories and potential expense categories. We can't give you the numbers, but you could use this as a working tool. You fill it in yourself. Problem there is it's a piece of evidence where many franchisees next claim, well, they didn't give me the information in writing, but someone on the phone or some other communication told me what to plug in. Or you have some salespeople by mistake share a pro forma that has financial information in it, which becomes a problem, right? Unit economics. On this front, unit economics, other litigation triggers and where you need to avoid. Item 7, estimated initial investment. Almost every time a franchisee attorney will claim that it was much more expensive to open up a location than the estimates in item 7. And many franchisors will say, well, I told them not to spend money on these things. They made these decisions and it was against our advice, or that the numbers are off. You know, litigation avoidance, clear item 7 disclosures, clear footnotes. If you're going to err on the side of caution, overestimate, create some clarity as your franchisees go through a development and build process. If they're not following system standards, not only advise them, but reject it, and reject it on the basis of what they're investing. And if they insist, then speak with your franchise counsel. We want to document their deviation and the obligations they're taking on against our advice. So reason number 2 for litigation, it's unit economics. Ways to avoid it: make sure your franchise opportunity aligns with the income potential, the economic opportunity you're offering them, right? Is it lifestyle, supplemental income, income replacement, or legacy building? Is that reflected in your FDD? And most important, is it reflected in your franchise sales process? If you're only supplemental income, why oversell extra territories? Or even if you're income replacement or legacy building, why are you going to have your franchisees spend more money on multiple locations when really we need to get them up and running in one location, make them successful? Other areas on the unit economic front, maybe you haven't included enough reserve capital estimates for the franchisees, or you haven't clearly defined local marketing obligations. Meaning, when there's a dispute arises, many times a franchisor will tell me, look, the franchisee is not being successful and they're frustrated. And I understand, but it's because they're not investing in marketing. And that's reasonable. And then you want to hear from the franchisee attorney, like, why are you not investing in marketing? Their claim is going to be, well, we don't have the money and we don't have the sales to support it. If we look at your item 7, it said only $15,000 in initial marketing. That's what we had, but it wasn't enough. Again, item 7, estimate investment, initial marketing. Have a clear game plan on what's required on that initial marketing to get that flywheel spinning. So reason 1 was compliance violations. It's not really the reason why someone is suing you. It's just an excuse, and it's designed for leverage. Unit 2, unit economics, and that is a primary catalyst for why franchisees sue. Reason number 3, operations and support. And really, that gets down to the day-to-day operational activity. Issues that franchisees and their attorneys will typically raise: 1, they'll point to training, that initial training was either inadequate or that there was no ongoing training program. 2, I'll call this support cadence or compliance cadence. Franchisor, franchisee, it's a relationship. There is a parent-child component to this. And when we see newer or emerging franchise brands, they really didn't have systems in place to keep franchisees in check. And when I say in check, meaning pathways and a cadence where they understand they need to report to your team is checking in, you're going through P&Ls, you're reviewing local marketing, you're identifying problems before they arise. Franchisee understands and sees that process and they comply with it. For newer or emerging brands, the problem is those first number of franchisees feel like they're pioneering, help create your system, and maybe you allowed them to develop bad habits. You didn't have that weekly, monthly, quarterly cadence as to reporting, as to financial review, as to local marketing. And now as your franchise system grows, you want to impose those items for their benefit, for franchisee benefit. And what you get is a mini rebellion. Again, it causes friction. So that support cadence, those compliance systems, you want to indoctrinate and train franchisees at an early stage that this is a mutually beneficial process and we need to adhere to it. Other operations and support, well, brand development fund, how it's used and how it's benefiting the system wide. And then I'm going to call the last item I call operations and support. I'll call it misaligned franchisees. What we see often is you have 2 franchisees, A and B, both have a similar experience, both have very similar financial results, and yet franchisee A is a raving fan and a happy franchisee, and franchisee B is not. And what are the reasons why? Well, because they probably didn't align with your franchise system. Maybe they weren't at the right stage of growth. Maybe they're too well capitalized or have too much money. And so your business is not a primary focal point. Or maybe they were buying the franchise for a child who's going to underperform and they don't represent your avatar franchisee. And where we do get concerned is if you have a franchisee that's not a good fit, who's very well capitalized with significant funds, they may be incentivized to sue, just to sue. So maybe this part could actually fit in the unit economics also, but misaligned franchisees are also a problem. So 3 reasons why franchisors get sued. 1, compliance violations. And again, they're just used for leverage, not the real reason for the dispute. 2, unit economics, and that could have to do with financial performance reps. Item 7, estimates, reserve capital estimates, local marketing, but most important, a misalignment on opportunity profile, that you may have sold a supplemental income business as legacy building or not meeting certain expectations that you set in the sales process, or worse, expectations that your franchise sales organization or outsourced sales organization created. 3rd reason, operations and support. Your franchisees need to perform, right? Supply chain efficiency improvements, training and support, right? Your goal as a franchisor is not adding extra expensive franchisees, but make their model more profitable than they operated on an independent basis. And of course, franchisee alignment. Those are the 3 reasons why franchisors get sued. And as we discussed, there's methods to avoid and mitigate against them. And along the way, as you work with your franchise counsel, these should be things that are planned out throughout the year. And they happen day to day on how we respond to franchisees with technical violations, substantive violations, and then for you, how you're controlling the franchise sales process. Own your franchise opportunity, understand the opportunity profile, align those expectations on day 1 in the franchise sales process. Don't let it be governed by brokers and franchise sales organizations. And if you do that, you're going to be cutting out substantial risk.